This case considered the issue of secret trusts and whether or not parole evidence was admissible to prove the terms of a trust in relation to a legacy in a man's last will. In this case, a man made a will where he declared certain legacies to beneficiaries where the income and some of the capital would be applied for the benefit of a person whose name was given to the trustee of his will. The residuary beneficiaries of the man's will brought an action against the trustees and argued that no such trust existed. They argued that the trust was not effectively declared and was therefore invalid. The central issue for the court was whether the secret trust was valid, or if the legacy was held on resulting trust for the residuary beneficiaries. The court ultimately held that parole evidence was admissible to prove the secret trust, and that there was nothing in the relevant legislation that contradicted the equitable enforcement of the secret trust. The Judge Buckmaster began by noting that the case involved whether or not the court could give effect to testamentary intentions that were not contained within a written document that has been duly executed as a person's will. Buckmaster surveyed the case law and referred to the earlier case of Crook v. Brooking, where the testator had created a secret trust with the executor, which was held to be valid after the executor revealed the secret trust upon the death of the testator. He stated that this is a perfectly clear case of a trust being revealed upon the face of the will, the terms of which were communicated to one of the executors. He also referred to the case of In re Fleetwood, where a similar such secret trust was approved by the court. The Judge Sumner also agreed that these cases on secret trusts, which had very similar facts to this case, were decided correctly. Sumner went on to discuss the equitable nature of a secret trust, and pointed out that equity permits parole evidence to prove what would otherwise amount to a fraud. He stated that a court of conscience finds a man in the position of an absolute legal owner of a sum of money, which has been bequeathed to him under a valid will, and it declares on proof of certain facts relating to the motives and actions of the testator, it will not allow the legal owner to exercise his legal right to do what he will with his own. He insisted that necessary elements of the secret trust and the invoking of the equitable jurisdiction is firstly intention, secondly communication, and thirdly acquiescence. He added that the testator intends his absolute gift to be employed as he and not as the donee desires. He tells the proposed donee of this intention, and either by express promise or tacit promise, which is signified by acquiescence, the proposed donee encourages him to bequeath the money in the faith that his intention will be carried out. In other words, it creates a trust. He pointed out that it is the creation of a trust that removes it from being governed by the legislation pertaining to wills and estates, and effectively brings it within the law of trusts. The Judge Warrington also discussed the issue of trusts, and stated that it has long been settled that if a gift be made to a person, but in fact upon a trust, communicated to the legatee and accepted by him, the legatee would be bound to give effect to the trust on the principles that the gift may be presumed to have been made on the faith of his acceptance of the trust, and a refusal after the death of the testator to give effect to it would be a fraud on the part of the legatee. The court therefore concluded that a secret trust did exist, and that the dispositions in the will were valid, and that there was nothing in the relevant legislation relating to wills that contradicted the equitable principles relating to secret trusts. In summary, this case is significant because it affirmed that the Court of Equity would uphold a secret disposition where a bequest is made in terms of a trust, but that the will does not disclose the terms of this trust. If evidence can be shown of intention to create a trust, communication of it, and acquiescence of it, then the court will admit the parole evidence outside the will to enforce the secret trust.